We live at a time when the scourge of political correctness has stifled constructive debate on a whole range of important issues. And one such issue is the extent to which pressure brought to bear by strident feminists has so adulterated our system of criminal justice that we can no longer say that all people stand on equal footing before the law. Over the last 50 years, I think it would be fair to say that alleged victims of sexual assault and those tasked with prosecuting those kinds of offenses did not always receive fair treatment before the courts. Now, what do I mean by that? Well, husbands had spousal immunity, meaning that they could not be guilty of raping their wives unless, of course, they were separated at the time pursuant to a valid court order. Boys under the age of 14 were presumptively and conclusively presumed to be incapable of committing the crime of rape. And women who consented to sexual penetration could not thereafter revoke that consent unless and until the male withdrew. So if sex was going on and the woman decided to curtail it or stop it, the male could continue over her protests, and at common law, shockingly, that would not have been the crime of rape. Now, over the past 40 or 50 years, happily, by judicial fiat and legislation, we have abrogated all of these archaic relics of the common law, so that when we did this, it appeared that the pendulum had swung pretty much back to the middle where it should be, and it looked like we had a relatively level playing field between the accused and the accuser in sexual assault cases. Now, having said that, and having taught criminal law in Victoria for some 25 years, over the past 8 to 12 years, I've noticed a rather disturbing trend in Victoria, whereby sexual assault offenses are now governed by a special set of rules that are not applicable to any other types of crimes, not even murder, kidnapping, armed robbery, treason, and I can go so on down the line. So what do I mean by a special set of rules that apply only to sexual assault crimes? Well, let me give you some examples of what I'm talking about. There is a truncated window of opportunity in which to file indictments and to commence legal proceedings, which applies only in sexual assault cases. And I view that as an expression by our Parliament in Victoria that they attach a higher priority to sexual assault crimes than they do any other types of crimes in Victoria, even murder, kidnapping, armed robbery, and those kinds of serious crimes. Why would that be so? Let's also talk for just a few minutes about committal hearings and how they're handled in Victoria. Now, for those of you that don't know criminal law or aren't familiar with it, a committal hearing is a proceeding before a magistrate at which the magistrate determines whether there is sufficient evidence on one or more indictable offenses to justify binding the accused over to stand trial in a higher court before a jury. And the way it works is that prior to the committal proceeding, the prosecution is required to hand over to the accused and serve a copy on the court of its hand-up brief. And included in that hand-up brief would be affidavits of all witnesses that the prosecution intends to rely on at the trial, as well as any other evidence that it intends to rely on in the event that a trial takes place. Now, in instances where the accused does not dispute criminal liability and intends to enter a plea of guilty, whether a straight plea or a negotiated plea, typically the way committal hearings are handled is that both sides consent to allow the magistrate to simply decide whether the evidence is sufficient to bind the case over before the guilty plea will take place. And it's done simply on the basis of the contents of the hand-up brief without the benefit of any live testimony being taken. But when the accused is going to dispute liability and take his or her chances before a jury, the situation is quite different, and the committal hearing becomes a critical stage of the criminal process. Now, I say that for a few reasons. First is that the defendant is in a position to compel the attendance of any prosecution witness whose affidavit is contained in that handout brief at the committal hearing. And all the accused really has to do to compel that attendance is to persuade the magistrate that bringing that witness in for cross-examination would assist the accused in the preparation of his or her case. And that's a very easy standard to meet, because it always would. Secondly, when you bring that witness in for cross-examination, there's a great advantage in doing that, because that gives you the utmost possible discovery of the prosecution's case, and you're in the best possible position to help your client, because the more you know about the prosecution's case, the better able you are to defend your client. And in a similar vein, and the final reason for this, is that when this testimony is given under cross-examination at the committal, it's going to be sworn testimony and it's going to be transcribed. And that means if the witness later testifies at the trial in a way that deviates from the way that witness testified at the committal proceeding, the defense counsel can take that transcript and impeach that witness's credibility through the use of previous inconsistent statements, and that can be absolutely devastating to the prosecution's case. In fact, the judge will instruct the jury that if you find that the witness has lied in one or more material facts, you may, if you choose, disregard that portion of the testimony, or if you choose to, all of that witness's testimony. That's how important it is. So that this is a big advantage to the accused to have this cross-examination. And in contested cases, you would be a fool as a defense attorney if you passed up the opportunity to exercise the right to bring these witnesses in at the committal hearing. Now, why am I talking about this in the context of sexual assault? The reason I'm doing this is because, as you might have guessed, we have a little bit different rules where sexual assault crimes are concerned. And that is that if the complainant happens to be a child or a mentally impaired person within the definition of the Criminal Procedure Act of 2009 Victoria, then we can't request and the magistrate can't compel either of those complainants, the mentally impaired or a child who is a complainant, to come in and be cross-examined. And that puts the accused at a distinct disadvantage because he can't get full discovery and he won't have nearly the amount of information gleaned from cross-examination of that person to use to impeach that witness's credibility should it deviate from the committal testimony at the trial. Now, one other thing I might want to add. If the state of Victoria, or any other jurisdiction for that matter, is so concerned about protecting children and mentally impaired people, I think there are a couple of considerations that we should think about. Some people might say, well, isn't it a good idea to protect people that are mentally impaired or children? And at first glance, it seems like a really good idea that we should do that. But it's only a good idea to protect people if we can first assume that the people who are the children or the mentally impaired making the complaints are telling the truth about whether, in fact, they were sexually assaulted, and, of course, whether the accused is the one that did it. The problem is we can't indulge that presumption at this stage of the criminal process, because at this stage of the criminal process, I think we all know, the accused walks into court cloaked with a presumption of innocence. And that presumption remains with the accused unless and until, if ever, the prosecution overcomes that presumption by evidence which proves that the accused has committed that crime beyond a reasonable doubt. So if we indulge the presumption at this stage of the proceedings that the complainant must be telling the truth, we have made a mockery of the presumption of innocence, have we not? And we can't do that. As much as we'd like to be generous to people with mental impairments or children, the fact is their testimony can be just as damning as that of any other person. That happens to be the way it is. And the other thing we should keep in mind is if the state of Victoria is so concerned about protecting these two classes of people, why don't they do it in any other case? Like, for example, if the complainant is a child or mentally impaired person and the crime against them alleged is kidnapping or something like armed robbery, which are two crimes that can be just as traumatic in their own way as rape or any other form of sexual assault, why don't we exempt them from being called at committal hearings in those cases? But we don't. We only do it in sexual assault cases. Now, third thing I want to talk about is what are often referred to as rape shield provisions. And they exist throughout Australia and throughout the Western world. And what these provisions basically do is they prevent the accused from adducing any evidence of the sexual history of the complainant, unless that sexual history is between the complainant and the accused, with one exception. If you want to adduce sexual history between the complainant and a third party, you can do it. But if you're going to do it, you have to show that the evidence is not only exculpatory, but substantially relevant, not just relevant, which is a term that all attorneys understand. But it has to be more than just exculpatory and relevant. It must be substantially relevant. And the problem with that is that there is no definition of substantial relevance anywhere in any statute located in the state of Victoria, nor at common law. So the concept of substantial relevance is a lot like what the late U.S. Supreme Court Justice Potter Stewart once said about obscenity. He said, "I can't define obscenity, but I know it when I see it." So if we have a definition of substantial relevance which is that ambiguous, and it's the linchpin of the rape shield provisions, how are we ever going to apply this law with any degree of consistency and fairness? And the answer is, we're not going to. Let me give you an illuminating example of what I'm talking about. Let's assume that I'm on trial for rape. Let's assume, of course, I didn't do it. And let's assume that my defense is that the entire encounter was consensual. And I say that it was not only consensual, but it was a kinky bondage type situation where unique requests were made to me, unique phraseology was used, unique devices were suggested, and things like that. Now, of course, I wouldn't do that sort of thing. But in any case, let's assume that I have the money, which most people don't, to hire an investigator who goes out into the field and they find one man, maybe two, maybe three, who were all prepared to come into court, and none of them know each other, none of them know me, no chance for collusion and fabrication to tell similar lies. And I want to bring them into court and have them testify that they had sex with the same complainant under the very same unique circumstances that I want to testify to. Now, the question is, if I want to bring one in, and I only have one, would the judge find that that was substantially relevant enough to get the evidence in? I think it should come in, but I don't know what a judge would say about that because I don't know what substantial relevance means. If there were two males, it's a stronger case. But would the judge let it in? I don't know. What if there were 3, 4, or 5? Well, at some point, it has to reach the level of substantial relevance. But we don't know at what point. Now, some people might say, well, what's the difference? Because if the judge excludes the evidence wrongly, you can always take the case up to the appeals court, or the Court of Appeals in Victoria, or maybe even the High Court. And eventually, if the judge made a mistake, you'll get a new trial. And if you're innocent, hopefully you'll be acquitted because the system is supposed to work. Of course, it doesn't always work the way it's supposed to, but we like to think it does. Well, that all sounds wonderful. But what if you're sitting in jail and you can't make bond? So the entire process of going through the first trial, the appeal, the second trial, which hopefully ends in an acquittal, what if it takes you 3 years and you sit in jail for 3 years until you get an acquittal? Is the state going to say that they're sorry? No. Are you going to get compensated for spending 3 years of your life in prison for a crime you didn't commit? No. And are you ever really going to get your life back because of the stigma that being tried for rape, even with an acquittal, will carry with it for the rest of your life? I think we all understand this. Just because a person is acquitted, it means they won't go to jail, but it doesn't mean people won't say, well, there's smoke, there's fire, and you know, it really bothers me that this person was on trial for rape. Maybe he just got off because he had a really good lawyer. And when I hear that, the hair on the back of my neck begins to stand up. But the worst part of the rape shield law, the worst part of it, I haven't even gotten to yet. And the worst part is, it's been the law for a couple centuries that all accused persons, until the advent of these rape shield laws came into being, was that any accused person charged with any crime had an unqualified right to adduce all exculpatory and relevant, just relevant evidence for his or her case. So if I'm on trial for a common assault where I punched someone in a pub one day, and my defense is self-defense, that it was the other guy who was the first to initiate the unlawful use of force against me, and therefore I'm innocent because I acted in self-defense. The common law has always allowed me to adduce all relevant exculpatory evidence. So I could introduce reputation evidence that that person has a horrible reputation in the community at large for being a violent person. And I could also introduce evidence of specific misconduct on the part of that person, such as that that person assaulted other people by initiating the unlawful use of force in the same way that he did against me, according to my testimony. There would be no problem getting that in. But you see, that's the way it is with all crimes. The accused is always allowed to do that, and there's no requirement that the relevance has to rise to the level of being substantial, which we don't even know how to define. Yet in sexual assault cases, we have a different standard. And we raise the bar and we say, if you don't get over that bar, the evidence does not come in. So, in my view, the rules that I've just alluded to are a manifestation of a strident feminist agenda to reshape our criminal justice system, and in these cases, our sexual assault laws, so that in the end, as a consequence, some people end up being a lot more equal than others. And that's a problem. Now, I wish I could tell you that these are the only pernicious effects that the strident feminist movement has had on our criminal justice system, but I'm going to give you some additional examples. Let's take the partial defense of voluntary manslaughter for just a moment. Voluntary manslaughter is essentially murder with extenuating circumstances thrown into the equation. Now, what do I mean by that? Well, one example would be there's a limb of voluntary manslaughter called the provocation limb, or provocation-type voluntary manslaughter, where the accused kills, but he kills in response to things that were said or done by the deceased in the presence of the accused on one or more occasions. And the jury would be told that if they find that the gravity of that provocation was such that it might have caused an ordinary person to react in the same way that the accused did and use deadly force and kill, that the verdict should be one of not guilty of murder and guilty instead of the lesser crime of voluntary manslaughter. Now, at common law, it was literally a matter of life and death whether your murder charge was reduced by the jury down to voluntary manslaughter, because at common law, murder carried a compulsory death sentence, but voluntary manslaughter did not allow for the death sentence. In Australia, we don't have the death penalty in any jurisdiction. But even in countries like Australia, where we don't have the death penalty, the maximum penalty for murder is always more serious than it is for voluntary manslaughter. So it does still make a big difference whether or not you're convicted of one crime as opposed to the other. Now, in 2003, despite the fact that there are two limbs of voluntary manslaughter, and I've just described one of them to you, the vast majority of jurisdictions in the Western world still continue to recognize both forms of voluntary manslaughter as extenuating circumstances that would reduce murder to a lesser offense. In 2003, I heard a rumor in Victoria that the Victorian Law Reform Commission, headed by then Professor Marcia Neave, who later became a Supreme Court Justice in Victoria and more recently chaired the Royal Commission on Domestic Violence in Victoria, she was then the chairperson of the VLRC, Victorian Law Reform Commission. So I called her and I said, Marcia, is it true that you're going to recommend the abolition of the provocation limb of voluntary manslaughter? And if you are, why? And she said, we're going to recommend it. And the reason we're going to recommend it is because it's a partial defense that is used by men to murder their wives and girlfriends. And I said, are you not aware of the fact that there's a woman right now up in Melbourne who's charged with murdering her husband, and she intends to rely on voluntary manslaughter to reduce the conviction. And if your recommendations were in effect at the time she committed the alleged murder, she wouldn't be able to rely on that defense, which you seek to take away in the future. And her response to me was, well, yeah, but Ken, that doesn't happen very often, that women kill their husbands or boyfriends. And I said to her, are you suggesting to me that if empirical evidence showed that women invoked the voluntary manslaughter doctrine, the provocation limb, with greater frequency, or at least as greater frequency as men, your recommendation would be the opposite. You would be in favor of retaining the defense. But because men, empirically, according to your findings, invoke it more often, you want to do away with it. I asked it 3 times, and she would never answer it, but she kept saying again and again, Ken, as I said, it doesn't happen very often that women do that sort of thing. Now, I came away with from that conversation, with a distinct point of view that the reason she wouldn't answer my question is because a truthful answer would have been, yeah. If women had invoked it more often than men, she would have been in favor of retaining it. So let's extrapolate her reasoning. We should do an empirical analysis on all the other defenses known to the criminal law. How about insanity, duress, necessity, diminished capacity, self-defense, defense of others, and so on down the line? I would be willing to bet that probably in every case, if not nearly every case, men invoke the defense with probably greater frequency than women do. So if we extrapolate her reasoning, we would end up abolishing every defense probably known to the criminal law. I've never heard anyone recommend anything quite that radical. Now, I might add that Victoria, in 2014, abolished the other limb of voluntary manslaughter, so that in Victoria, that alternative to murder doesn't exist at all anymore. And in both cases, if you look at the explanatory memoranda, in both cases, where it was abolished by statute, both limbs, if you look at the second reading speeches, it's plain that gender bias was the sole consideration in abolishing that alternative defense in Victoria. And Western Australia, Tasmania, and New Zealand have abolished one or both limbs and followed suit. And I'm sure other jurisdictions in the Western world are probably contemplating doing something similar, although the overwhelming majority still continue to adhere to the view that these limbs of voluntary manslaughter should still be full defenses, in at least the partial sense, to the crime of murder. Now, I think the worst example and the most glaring example of the effects of strident feminism and their lobby on our parliament is embodied in Section 6 of the Crimes Act 1958, Victoria. Section 6, it's called the crime of infanticide. Infanticide is essentially murder, except that it's committed by a woman on her child or children within 24 months of the time that they are born. And at the time of the act causing death, the woman is suffering from postpartum depression or any mental disorder, even one which is not recognized in the psychiatric community. So let's think about this for a minute. If a woman gives birth to twins and she can't cope with motherhood and she's depressed and she runs to her general practitioner and says, I'm not coping well with this. I'm depressed, I'm having trouble sleeping, and I really don't enjoy it. It's tougher than I thought. And the GP says, here, I'll give you some Prozac. You should be fine. This is a rather common thing for mothers to go through. Come back and see me in a month. But she's not fine. And in 2 weeks, she drowns both twins in the bathtub. Now, the jury would be instructed in a case like that if they found that all the requisites of that statute were met, that they should acquit her on 2 counts of murder and instead find her guilty of the lesser crime of infanticide. And boy, is it ever a lesser crime. Murder is punishable by 25 years to life. So she could have been facing 25 years to life on each count, which could have been run consecutively, which means she would never see the light of day. Instead, because infanticide is a penalty level 6 and murder is a penalty level 1, which is the highest, and infanticide is way down the ladder, it's punishable by, get this, 5 years maximum in prison. And the judge can impose a non-custodial probationary sentence on both counts. So if the judge is so inclined and he's sympathetic, he can say, well, the jury found you guilty of 2 counts of infanticide. And I'm going to give you a couple years probation on each count, 1 for each twin, and I'll run them concurrently so that you don't spend 1 day in jail because I'm sympathetic to what happened. Now, let's reverse the facts a little bit. What if it's a male who says, I don't want any kids, to his wife or girlfriend? And she says, I agree to that. But she deceives him into believing that she's taking birth control pills, but she's not. She becomes pregnant and she gives birth to twins. And the male, having had twins foisted upon him, becomes depressed. So under similar facts, he runs to his general practitioner and says, I'm not coping with this. I can't sleep. I'm miserable. I'm depressed. And the GP does the same thing. He gives the same antidepressant, Prozac or Zoloft or something like that, and says, come back and see me in a month. You should be fine. This is pretty common. And he goes off half-cocked. And he drowns them both in the bathtub. Is he eligible for the leniency of infanticide, that she's eligible for? And the answer is no. The crime he faces is going to be 2 counts of murder. And the jury has 3 choices: guilty, not guilty, or a hung jury, in which case the prosecution can retry the case. Now, how in the world does any rational, fair-minded person justify the disparate treatment of one gender as opposed to the other? And the answer is, you don't, in my opinion. Now, if feminism means equal pay, equal work, then I'm a feminist, and probably everyone here is. And if feminism means that women who want to play Aussie rules football or rugby union or rugby, and they're good enough and willing to play with the boys, should be allowed to and earn similar pay if they're good enough, I think probably everyone here would be in favor of that. I know I would be. So if that's what a feminist is, then I'm a feminist. But if feminism means preferential treatment for one gender in promotions, hirings, university admissions, and so on and so forth, I think all reasonable and fair-minded people have to say, enough is enough. Because if we do that, we are not equal before the law, and that is a key staple of our criminal justice system and our society at large, is it not? Now, having talked about what feminism can mean, which is preferential treatment for one gender at the expense of the other, which I think is the new wave of feminism, which I call strident feminism, let me give a couple additional examples. About 10 years ago at Deakin University, our female vice chancellor sent out a global email inviting everyone to apply for admission to membership on the 9-member university's curriculum committee, with instructions as to where to send your CV. And there was an asterisk at the bottom of the letter that said, oh, and by the way, there have to be a minimum of 4 women on that committee. Now, if I'd been the vice chancellor as a male and written that same global email, and the asterisk said there have to be a minimum of 4 men on the committee, how long do you think my tenure as vice chancellor would have lasted at Deakin University? What do you suppose my treatment would have been at the hands of my colleagues? How do you think the strident feminist lobby, if they got wind of that, would have reacted to it? How do you think the press would have reacted to it? And maybe we should ask former New South Wales magistrate Pat O'Shane a little bit about what happens when you offend the dogma of strident feminist thought. She would have a lot to say about that, I believe. Now, I think the example that worries me the most, that scares me the most, is that in 2014, when we revamped our sexual assault laws in Victoria, which we did, Associate Professor Wendy Larkham of Monash University made a submission to the Department of Justice in Victoria that was joined in by several women's rights organizations, and I think they would have no problem at all saying that they were strident feminist organizations. And they made a bunch of recommendations that they asked Parliament to follow in changing our sexual assault laws. And some of them were adopted, and I find that they were ill-advised. But those are not the things that worry me the most about what happened in 2014. What worries me the most is some recommendations that Larkham and these organizations made, which at the time Parliament did not accept. But I believe if the present trend continues and nothing is done to curb this trend toward political correctness run amok, that all these things will become law eventually because of pressure brought to bear. That's my biggest fear. So let me tell you what some of these recommendations were that our Parliament did not adopt in 2014, and we'll see what you think about them. First, any sexual encounter that takes place, the person who initiates it, which they believe will always be the male, of course, which isn't true, should take all necessary and reasonable measures to ensure that they have consent. So that means if you're having sex with someone that you normally have consensual sex with and there's never been a problem, now you have to say before you do anything, do I really have your consent? And you might want to get out a form and say, check the boxes as to what you consent to and what you don't consent to and what devices can be used if we're going to get kinky, and tell me what I can use and what I can't use to protect yourself. And maybe she might hand you a similar form to protect herself. I want you to think about the effect that would have on sexual conduct among normal adult people if we adopted a law like that. Here's another recommendation she made. She said that in sexual assault cases, what we should do is we should prohibit any jurors, defense attorneys, prosecutors, or judges from taking part in any trial involving a charge of sexual assault unless they have specialized training, I kid you not, in the area of sexual assault. I don't even know what specialized training would be in the area of sexual assault. And she didn't say, but I would assume it would mean something like mandatory internships for all of us who want to be jurors or defense attorneys, prosecutors, or judges in these cases, mandatory internships at local rape crisis centers, maybe taking courses in women's studies, maybe all of the above. I don't really know. But think of the affront to the common sense of those jurors, judges, defense attorneys, and prosecutors to insinuate that they would have to go through the burden of doing all of that to take part in these kinds of cases. Why don't we require the same kind of special training in kidnapping cases? How about armed robbery cases? How about murder cases? How about treason cases? How about arson cases? And yet we don't do that. And their recommendation was only to require the special training in sexual assault cases. Lo and behold. Another recommendation, that judges ought to have the power in any sexual assault case to curtail cross-examination of a complainant if the judge finds that that cross-examination was intimidating, intrusive, humiliating, or overbearing in an unduly way. As a former trial attorney, I can tell you that by its very nature, almost any tough cross-examination, and sometimes you have to be tough, is going to be one or all of those things. In fact, some people think that cross-examination is the best device known to the law, or maybe even mankind, for sussing out the truth and exposing perjured testimony. So, if an accused can get past the rape shield law by being able to bring in evidence of sexual history between the complainant and a third party, the judge might say, well, but I'm not going to let you cross-examine the complainant about that sexual history if this law had been adopted by Parliament, which, fortunately, again, it was not. And the most outrageous recommendation I want to mention, and there's more I could mention, listen to this one. In any sexual assault case, the organizations and Larkham recommended that a complainant be allowed to give a victim impact statement to the jury before the accused is allowed to adduce any evidence of sexual history or any medical reports that would bear on the credibility or the case in general relative to the complainant. Now, even in jurisdictions, and not all of them allow it, which do allow victim impact statements, it's never allowed until the jury has come back with a verdict of guilty, and I think that makes good sense. And so this is another instance where what the feminists are trying to do is subvert the presumption of innocence and indulge the presumption that the woman must be telling the truth. And if she's not telling the truth, how can we call it a victim impact statement at that stage of the process before the case has gone to the jury? And of course, the jury could very well come back with a verdict of not guilty. What an anomaly to have a verdict of not guilty in a case where you have someone making a victim impact statement. That's to make a mockery out of the presumption of innocence, in my view. Now, I think that political correctness can be defined in any number of ways, and I would define it as not saying anything or doing anything which might offend even the most sensitive person in our society or in some big group. And as long as we can continue to be governed by considerations of PC, our society is going to continue to regress and not progress, and that's not going to be good for anyone. So the question is, what can and what should we do about this problem? Well, enhanced public awareness of all the things that we've been talking about in this conference is certainly the key. But as we all know, that's a lot easier said than done, isn't it? But I think another place we have to start is with our parliamentarians. Our parliamentarians are very keen to get reelected. And the reason they're so keen to get reelected is because in Victoria, for example, all of our parliamentarians are currently making, I believe it's $195,000 a year, which is roughly 400% what the average Australian man or woman earns per annum. If they get reelected one or more times, they also qualify for exorbitant pensions, which are far beyond the reach of the average Australian man or woman. The effect of those salaries and exorbitant pensions is to make our elected representatives extremely vulnerable to special interest groups who wield considerable political power. So what I would recommend is that we minimize that vulnerability by reducing those salaries and those pensions significantly. I'm not saying that that's going to entirely solve the problem, but it certainly would amount to a step in the right direction, I believe. So I want to leave you today with a quotation from the late Angela Lambert, who was herself an avowed feminist in the United Kingdom. And this is what she had to say about the new wave of feminists prior to her death. And I quote, "There are plenty of reasons why a woman might falsely accuse a man of rape. The belief that all women are truthful and all men are rapists does not prove us good feminists. Quite the contrary, it reveals us as prejudiced, narrow-minded, and as bigoted as any racist." Thank you very much for your time.
Can you stay just for one question? 4 minutes, one question.
Thanks very much for the talk. I understand that recently the Victorian Parliament has changed the law so that an accused person in a domestic violence situation can't cross-examine the alleged victim. That seems to me like a complete travesty of justice. Obviously, that will also have implications for sexual violence allegations. Would you care to comment?
Well, as a criminal law specialist and a person that taught criminal law and evidence for a long time, domestic violence is really not an area that I've delved greatly into. But the speaker to follow me, Augusto Zimmerman, is going to address the very point that you raise. So I think the more appropriate person to address that question to, who knows far more about it than I do, would be Augusto.
In that case,
but I do agree with you that on the face of it, it does sound extremely unfair and pretty typical of what I've talked about.
in that case, just one very quick last question.
Yeah, sure.
I'd like to know, is there a way where we can make men and women equal, like in laws? Say, if you would talk about infanticide, can a male be charged with infanticide as well? And how do we get there to change that law so it's equal on gender-neutral terms?
Well, the answer is that right now, under Section 6 of the Crimes Act 1958, and please read that statute. Anyone that's here, take a look at it. A male is simply not eligible to be convicted of infanticide. He doesn't have the option with the jury to come back with not guilty of murder, but guilty of the lesser crime of infanticide, which would mean that the maximum he could face, if the judge were to throw the book at him, would be 5 years on each sentence to run consecutively. But of course, the judge could impose on that woman, as I pointed out, 2 non-custodial probationary sentences and run them concurrently. So in the end, the woman could serve not one moment in jail. But a man has no eligibility because the statute has no application whatsoever to men. And that's my big gripe. Why doesn't the statute apply to men who kill their children within 24 months of birth under some kind of depression or mental disorder in the same way that women do? And with women, the mental disorder doesn't even have to be psychiatrically recognized. So it can simply be a matter of running to a GP and saying, I'm having problems coping with my new children. I'm having trouble coping with motherhood. I need help. I can't sleep. I don't know what to do. I'm not very good at this. Help me. And so the doctor gives her Zoloft or Prozac or some kind of antidepressant. She kills, she can qualify for the infanticide and the non-custodial sentence. But a male who does the same thing faces the charge only of murder, which is punishable by 25 years to life. So in answer to your question, what I think we should do is we should amend our law so that men who kill under the same or similar circumstances are eligible for the very same treatment that women are. If you believe it's a good idea for women, why shouldn't it be just as good an idea for men?